Hello, and welcome to HIPAA training. Today we're going to be learning the ins and outs of the federal legislation known as HIPAA. HIPAA is federal legislation along with accompanying regulations concerning how medical information is handled. It is an acronym that stands for Health, Insurance, Portability, and Accountability Act of 1996. Remember 1 P and 2 A's. The increasing demand for access to medical information by healthcare providers, insurance companies, and others led to heightened concern about patient privacy and confidentiality, which resulted in the enactment of HIPAA. Its original goals concerned how insurance coverage could be transferred when individuals changed employment, as well as fraud and abuse in the healthcare industry. It came to encompass much more in its final form. Prior to HIPAA, no generally accepted standards or requirements for protecting health information existed in the healthcare industry. Additionally, new technologies were emerging at this time, promoting increased efficiencies, but also presenting increased risk to patient confidentiality. The administrative simplification provisions are what we need to be most concerned with today. These were passed in order to protect the privacy and security of certain health information and promote efficiency in the healthcare industry through the use of standardized electronic transactions. Electronic exchange refers to specific and distinct HIPAA activities involving the electronic transfer of healthcare information for particular purposes. Examples of these activities are claims or encounters, remittance advice, eligibility, and claim status inquiries, as well as a host of others. Under HIPAA administrative simplification, if a business engages in one or more of the identified electronic transactions, the business must comply with the standard for that transaction. Security refers to the standards set for ensuring the confidentiality, integrity, and availability of electronic health information. We will be examining this concept in a later module. Privacy refers to the standards set to protect the use and disclosure of health information. This will be our main focus today. HIPAA changes the way organizations deal with people's healthcare information. HIPAA law and regulations apply to several different types of organizations commonly referred to as covered entities. Individual and group health plans that provide or pay the cost of medical care are covered entities. Health plans include health, dental, vision, and prescription drug insurers, health maintenance organizations, or HMOs, Medicare, Medicaid, and long-term care insurers. There are certain exceptions that we don't need to be concerned about today. Every healthcare provider, regardless of size, who electronically transmits health information in connection with certain transactions is a covered entity. These can include institutional providers such as hospitals, non-institutional providers such as physicians, dentists, and other practitioners, and any other person or organization that furnishes, bills, or is paid for health care. Healthcare clearinghouses are organizations that process non-standard information they receive from another entity in a standard format, or vice versa. These organizations include billing services, repricing companies, community health management systems, or value-added networks. Business associates are persons or organizations other than a member of a covered entity's workforce that performs certain functions or activities on behalf of or provide certain services to a covered entity that involve the use or disclosure of health information. Examples of these types of activities are claims processing, data analysis, utilization review, and billing. It should be noted that the covered entity can be the business associate of another covered entity. When a covered entity uses a contractor or other non-workforce member to perform these business associate services or activities, HIPAA requires that the covered entity include certain protections for the health information in a business associate agreement. Patients are covered by the HIPAA law and its regulations. Specific rights are expressly created regarding their health care information that we'll be covering extensively in an upcoming module. And most importantly, HIPAA applies to you. As an employee of a covered entity, you are responsible for adhering to all of its provisions, as well as the express policies and procedures as set forth by your employer. Significant sanctions for non-compliance will be explained further in another upcoming module. Now that we have determined whom HIPAA applies to, we can examine what information is actually protected. This information is known as Protected Health Information, or PHI. HIPAA protects all individually identifiable health information, including demographic data that relates to 1. The individual's past, present, or future physical or mental health condition, 2. The provision of health care to the individual, or 3. The past, present, or future payment of the provision of health care to the individual. What this means is that HIPAA has broadened the definition of health information to include not only the clinical medical record or chart, but also to include financial, demographic, and lifestyle information maintained on patients and clients. The privacy regulations contain provisions by which a covered entity can purge identifying information from health information, and thus remove such information from the category of protected health information. There are no restrictions on the use or disclosure of de-identified health information. In order to de-identify health information, a covered entity must remove all sufficient elements from the information so that there is no reasonable basis that the information can be used to identify the individual. The privacy regulations set forth 2 ways to de-identify health information, either 1, a formal determination by a qualified statistician, or 2, the removal of specified identifiers. These identifiers to be removed are name, geographic divisions, dates except year, telephone number, fax number, email address, social security number, medical record number, health plan number, account number, license number, vehicle number, device serial number, URLs, IP number, biometrics, full face images, or any other unique identifying number, characteristic, or code. HIPAA sets forth certain administrative requirements that covered entities must implement in their organizations. Recognizing that covered entities will vary in their size and resources, there is a flexibility built into these requirements to allow covered entities to analyze their own needs and implement solutions appropriate for their own circumstances. Each covered entity must develop and implement written policies and procedures that are consistent with HIPAA regulations. The Wayne County HIPAA Privacy Policies and Procedures Manual should be your reference guide for these issues. In addition, your own division may have additional policies and procedures that are tailored to the type of work that you are doing on a daily basis. A covered entity must designate a privacy official as well as a contact person or office responsible for receiving complaints and providing information on the covered entity's privacy practices. Your individual department may designate a deputy privacy official also. A covered entity's workforce members, as well as any other persons under the direct control of the covered entity, must be trained as to its HIPAA policies and procedures. In addition, if there is a material change to either the policies and procedures or an employee's job functions, additional training is required. A covered entity must have and apply appropriate sanctions against members of its workforce who fail to comply with its own policies and procedures and those requirements of the HIPAA regulations. We will examine these sanctions further in just a few minutes. A covered entity must mitigate, which means take steps to correct and diminish, to the extent possible, any harmful effect of a known wrongful use or disclosure of PHI. A covered entity must have in place appropriate administrative, technical, and physical safeguards to protect the privacy of PHI from any intentional or unintentional use or disclosure that is in violation of HIPAA. We will take a closer look at these safeguards in the security module of this training. A covered entity must provide a process for individuals to make complaints concerning the covered entity's policies and procedures, and its compliance or non-compliance with such policies and procedures, and the HIPAA regulations. Among other things, the covered entity must identify to whom individuals can submit complaints and advise that the complaints may also be submitted to the United States Department of Health and Human Services. A covered entity may not retaliate against a person for exercising rights provided by the privacy rule. for assisting in an investigation by the United States Department of Health and Human Services or another appropriate authority, or for opposing an act or practice that the person believes in good faith violates the privacy rule. A covered entity may not require an individual to waive any right under the privacy rule as a condition for obtaining treatment, payment, and enrollment or benefits eligibility. Finally, a covered entity must maintain for at least 6 years its privacy policies and procedures, its privacy practices notices, disposition of complaints, and other actions, activities, and designations that the privacy rule requires to be documented.